Welcome to the award-winning Consumer Finance Monitored podcast, where we explore important new developments in the world of consumer financial services and what they mean for your business, your customers, and the industry. This is a weekly show brought to you by the Consumer Financial Services Group at Ballard Spahr Law Firm. And I'm your host, Alan Kaplinski, the founder and former practice group leader for 25 years and now senior counsel of the Consumer Financial Services Group at Ballard Spahr. And I'll be moderating today's program. For those of you who want even more information about the topic that we're going to be discussing today, or for that matter, anything else in the world of consumer financial services, don't forget to consult our blog, which also goes by the name of consumerfinancemonitor.com. We've hosted the blog since July 2011 when the CFPB became operational, so there is a lot of relevant industry content there. We also regularly host webinars on subjects of interest to those in the industry. So to subscribe to our blog or to get on the list for our webinars, please visit us at ballardspahr.com. And if you like our podcast, please let us know about it. You can leave us a review on whatever platform you use, be it Apple, YouTube, Spotify, or any other major platform. Also, please let us know if you have any ideas for other topics that we should consider covering or speakers that we should consider inviting as guests on our show. So let me tell you what we're going to be talking about today. We're going to be talking about a brand new opinion from the First Circuit Court of Appeals in a case called Conti versus Citizens Bank. At issue in the case is whether or not the National Bank Act preempts a Rhode Island law which requires banks to pay interest on mortgage escrow accounts. Mortgage escrow accounts are amounts that borrowers need to pay to their lender to cover taxes and property insurance, and the monies are held in escrow until they actually become due and the payments are made by the lender. And so some states like Rhode Island, and there are many others, have laws that require that a minimum amount of interest be paid on those mortgage escrow accounts by the lender to the borrower. So I've identified the issue. The district court in this case quite some time ago, because this case has been to the district court and it was at the Court of Appeals and it was stayed there for quite some period of time. But the district court decided that yes, holding that the bank, the district court said that the bank had a National Bank Act did preempt the Rhode Island state law. But the First Circuit disagreed with this opinion that just came down. This decision follows very closely on the heels of another opinion in the U.S. Supreme Court called Cantero v. Bank of America, which together, these two cases, unfortunately, have the possibility, and it could be a likelihood, of reshaping how courts analyze national bank preemption cases. So we're joined today by two of my colleagues at Ballard Spahr, both partners at the firm and in the Consumer Financial Services Group that are truly experts in this area, that have been dealing with national bank preemption for many, many years and have been following this Conti v. Citizens Bank case very closely. This is one of other cases around the country, which we'll talk about in a bit, relating to the same issue, whether the National Bank Act preempts state laws requiring the payment of interest on mortgage escrow accounts. So first of all, before we get into a lot of questions that I have for two of my guests, let me introduce them. First, Joseph Schuster. Pleasure to have you, Joseph, on the show. I can't wait to hear what you're going to say about this case and its implications.
Thank you, Alan. I'm excited to be here, and this is a very interesting topic, and it's really going to be a major change for the industry. So looking forward to discussing.
And Ron, I'm also equally grateful to you that you'll be able to share your wisdom about this case with our audience today.
Thank you, Alan. Appreciate the opportunity.
Okay, so let's start with the basics. I'm going to start with you, Joseph. What happened in this case, Conti v. Citizens Bank?
Yeah, great question. And I'm going to back up just a little bit and share that national bank preemption is a concept that has been around for a very long time. National banks have specific powers to do things, to make loans, take deposits, establish escrow accounts, all of these different powers that are granted to national banks by the National Bank Act. It has long been the belief that most state laws that interfere with their abilities to do those activities are preempted. And the OCC has come out with guidance that you could maybe call field preemption to say that any laws relating to specific topics like contract requirements, escrow accounts are preempted by this federal law. This has recently been, well, and I say recently, but I guess it goes back over a decade at this point. It's been a topic of controversy. It was specifically addressed in Dodd-Frank. It went dormant for a period of time, and then Alan, like you said, it was brought up just last year with Cantero. So we were really expecting national bank preemption to be changing after Dodd-Frank. To our surprise, that did not happen. Now it does seem like things have moved through courts that where Dodd-Frank may have been trying to push preemption may be happening. So, but to your question of what happened in Conti v. Citizens Bank, originally, the case was dismissed, saying that the Rhode Island law was preempted by the National Bank Act. That happened prior to Cantero. As a result of Cantero, the First Circuit reevaluated this and said that the district court did not have the benefit of that Cantero analysis. And as a result, the First Circuit held that this Rhode Island law is not preempted by the National Bank Act. Now, I could get into the mortgage escrow piece specifically, but I think that the implications of this are much broader. So that it's a state law that the industry, the national banks, thought were preempted for quite some time. And now we have the First District saying that is not the case.
Yeah, I agree with you, Joseph. We don't need to get into the nitty-gritty of mortgage escrow laws and interest rates that are paid on them or have to be paid by the lender to the borrower. But I think in order to really understand what the First Circuit did in Conti, we need to go back to Cantero, because Cantero set the stage for this opinion. Cantero was, at least to me, a very disappointing opinion. I think it was actually a unanimous opinion. I think the only way they could make it unanimous is to come up with an opinion that held nothing. I mean, it provided literally, I thought, zero guidance what the lower courts ought to do here. But let's talk about that. Let's talk about how that Cantero, what it held and what kind of guidance, if you want to call it that, they gave to the First Circuit.
Yeah, it's a great point. And it is why the First Circuit went in the direction that they did here and why they went in a direction different than the district court. So Cantero was, really the first time that the new standard by Dodd-Frank was evaluated, certainly by the Supreme Court. So it was central to the First Circuit's reasoning. The Supreme Court held in Cantero that courts must conduct a nuanced comparative analysis when deciding whether a state law is preempted. That means looking at the state law's practical effect, comparing it to cases where preemption was found. Some of these cases are specifically mentioned in Cantero, like Barnett Bank, Franklin, and cases where preemption was not found. And they talk about Anderson, Commonwealth, some other ones, and then deciding whether the state law's interference is more like one set of cases or the other. And that's exactly what the First Circuit did here.
And none of those cases dealt with mortgage escrow accounts, right? Or anything even close to mortgage escrow accounts.
No, and It's what they have to compare them to. And when they compared them, they found that Rhode Island's law is not materially inconsistent with federal banking and does not prevent national banks from exercising their powers.
Yeah. Well, these other cases, I mean, Barnett Bank, yeah, I get that. Barnett Bank, just for the sake of our listeners, involved a Florida statute that said a bank couldn't own an insurance agency. And the litigation involved the question of whether the National Bank Act preempted that Florida statute. There, under the National Bank Act, banks are allowed to open up insurance agencies in small towns that have a population of, I don't know, less than 5,000 or something like that. So there was a very direct conflict between the National Bank Act and the Florida statute. It's an easy result. That really doesn't resolve the issue. But the other cases, two of them dealing with the sheet laws, one came out one way, one came out the other way. The First Circuit seemed to somehow think, or it seemed to take out of all these cases the principle that unless there is some kind of conflict, unless there's something in the National Bank Act that expressly or comes pretty close to saying that national banks don't have to pay interest on mortgage escrow accounts, you're out of luck. I mean, at least that's how I looked at it.
I agree. I think the standard is becoming, from where the standard was, which I would say was very low. Like I'll tell you, prior to rejoining Ballard, I spent 8 years at a state-chartered bank. State banks do not have the same preemption authority as national banks. I was very jealous of my national bank peers because they did have this field preemption from the OCC. Where these cases are moving things now is much closer to where state banks were, I think, with respect to preemption. And they're really saying that state laws are preempted only if they discriminate against a national bank or prevent or significantly interfere with their powers. And like we saw in this case, that determination must be made on a fact-specific, practical assessment. That's a very high bar.
Yeah, for sure. So, Ron, Joseph made reference to the OCC, and it said that the OCC has weighed in. Indeed, they've issued regulations. I think the first set of regulations they came up with may have been in 2004. I mean, it was a long time ago. Tell us a little bit about what the OCC did in their regulations. They didn't use, they sort of used what I would call categorical preemption. Right?
Exactly. I think that's probably the way to describe it was categorical preemption, including with respect to interest on escrow accounts, specifically to state that banks could charge it or that states could not regulate escrow accounts.
They actually expressly say that in the reg.
Correct.
Yeah, as well as a lot of other things, right? There are a whole litany of state laws.
A whole litany of categories of state laws that the OCC had determined were preempted by the National Bank Act.
Wow. So that's in 2004. Let's say you were giving advice to a client back then. That's even prior to Dodd-Frank. And would you have ever said to the client, "Oh, the OCC's wrong. You can't do that. You got to comply with state law"? What do you think? What's the reaction of national banks to that?
Yeah, I don't think that works. I mean, prior to, last year's determination by the Supreme Court in the Loper-Bright case, the courts would have been required to give deference to OCC interpretations that were reasonable. I think it was a reasonable interpretation. It was certainly hard to challenge. The courts did give a lot of deference to OCC interpretations regarding preemption. And I think, the Loper-Bright case changed a lot of that. But more importantly, probably, was the Cantero case. And there, the Supreme Court specifically said the test is not a categorical test that would preempt virtually all state laws that regulate national banks. I think by saying that, they were basically just saying, we reject what the OCC has done.
Although interestingly enough, they didn't expressly reject the OC. They didn't even mention, well, I think in a footnote, I recall in Cantero, toward the end of the opinion, they made some reference to the OCC regulations. And indeed, they, in a very puzzling way to me, they instructed the court on remand, the Cantero court, to consider the OCC regulation. And I couldn't figure out why they did that, but
yeah, I mean, in particular, since they said it's not a categorical test, which seems that the OCC's test was a categorical test.
Right. So then you've got the Dodd-Frank Act. Can't remember the year it was enacted. I don't know if either of you remember. But a Dodd-Frank Act began, well, actually, I do remember now. It was 2010 because the very same statute created the CFPB. And in there's a whole section dealing with National Bank Act preemption. Can either of you just tell us briefly, essentially, what did Congress do at that point?
Sure. In Dodd-Frank, Congress had, in Section 25B of Dodd-Frank, said that consumer financial protection laws are preempted only if they have a discriminatory effect on a national bank as compared to a state-chartered bank, or prevent or significantly interfere with the exercise of national bank powers in accordance with the legal standard for preemption in the decision of the Supreme Court in Barnett Bank. So specifically adopting the Barnett Bank standard in Dodd-Frank.
They went a little further too, didn't they? They required there to be it should be a case-by-case analysis and implied that it should be a fact. Almost you had to look at the facts of each individual case. And I think correct me if I'm wrong, I think they also instructed courts not to defer to the OCC. Am I right about that? They said that, at least I have a vague recollection there's something about that. Is that wrong?
They certainly had that you had a facts and you had to look at the facts and look at things on a case-by-case basis. And I think that's where we thought coming out of Dodd-Frank that the OCC was going to have to remove their regulations or significantly revise it, look at things more on a case-by-case basis. And they really came out, and there are specific requirements about how the OCC is supposed to look at things from a preemption standard too. They basically came out and said, we've looked at what we have and we're basically reinforcing that we are confident with the preemption preemption standards that we have. But I'll let Ron add some other points too.
Yeah, what else, Ron?
Yeah, I think that's right. I mean, in particular, Dodd-Frank said that specifically that National Bank Act does not occupy the field with respect to preemption of state law.
Yeah. But the OCC thought it was business as usual. They basically said, we've looked at our regs and we think Congress essentially put the rubber stamp on our regs.
Yeah, I mean, I think their view was, well, our regs are consistent with Barnett, and that's Congress telling us that we did it right.
Yeah, okay. So why, Ron, is this such a significant case for the banking industry? I mean, this deals with mortgage escrow accounts. Usually, the state laws don't require you to pay a lot of interest on mortgage escrow accounts. It's not really that. It doesn't seem to cost a lot. It's not going to cost the bank a lot of money. But why is this so important?
And most states don't even require you to pay interest on escrow accounts. So it's seemingly on its face kind of a minor decision, but the implications of it could be very big. It certainly has no effect with respect to anything that the bank can do insofar as preemption related to interest rates on lending activities. That's completely different here because there is a direct conflict between federal law and state law.
Could you just explain that just a little bit more, Ron? Because I think there's a lot of confusion about it's sort of a bifurcated kind of National Bank Act preemption. There isn't one standard. There's like two standards. There's a standard for interest, state usury laws, and there's a standard for other state laws. So how does that work?
For usury purposes, Section 85 of the National Bank Act controls, and it says that the National Bank can charge interest either at the rate allowed in the state where it is located or at a rate that is 1% higher than the prevailing Federal Reserve discount rate. So there's a specific rate that the banks are allowed to charge under federal law. Under everything other than loan interest, there is nothing that specifically, for the most part, I can't think of anything right now of any situation where there is a specific contradiction with respect to state laws. The National Bank Act grants these broad authorities to banks, but doesn't specifically say these are the fees that you can charge, for example, or this is the amount of interest that you must pay.
Right. And then there's a Supreme Court opinion in 1979 or 80, Marquette National Bank versus First of Omaha Service Corp, right?
Right. Well, that really opened the door to interstate banking with respect to lending activities because it allowed banks, or it interpreted the National Bank Act, Section 85, to say that banks can charge interest at the rate of their home state to customers who are located in other states, and contrary to and ignoring the laws of the states where the borrower, the customer, resides. That applies only to lending activities.
So the important point here, and then I've gone to a lot of additional questions to ask, is that the issue in Cantero and the issue in Conti does not deal with Section 85 of the National Bank Act. It deals with other portions of the National Bank Act, the incidental powers sections, Section 24/7, I think it is, but it doesn't have anything to do with Section 85. So I think we may have already answered my next question for you, Joseph. That is, what is the current preemption standard? I think, well, let's just, reiterate it because it's really key to understanding how this whole framework works.
Well, it's your question's more nuanced, I think, too, than it may lead on. The current preemption standard, we're going to get into that. There's a couple of other cases that are out there, too. We have been working with some national banks who are reassessing the state laws with which they're complying. However, there are national banks who are still trying to figure out where things are going with these cases. But I would say that and I think Cantero discusses it. I think Dodd-Frank discusses it. So in my mind, it's a pretty clear standard. And that is that state laws are preempted only if they discriminate against national banks or prevent or significantly interfere with their powers. And that determination must be made with a fact-specific practical assessment. So let me just break that down into a couple of little pieces, if you don't mind. Like, number one, discriminate against national banks. That has to be that the law says national banks must do this. Doesn't apply to others. It only applies to the national bank. That is discriminatory. And you can think about different state laws to which these can apply. Now, this case deals with escrow accounts, but think about things like disclosures, contract terms. There are state laws out there that say, your first payment must be 15 days after, but no longer than 45 days after. You have requirements that maybe the loan agreement needs to be, a copy of the loan agreement needs to be marked paid in full and provided to the consumer afterwards. There's a lot of things that are out there from a state law perspective that just have not been on the radar of many national banks because of the OCC's view that these were preempted and national banks following that. So that first piece, discriminate against national banks, I don't think you're going to see that very often. In fact, a lot of these statutes do have exemptions for national banks, but not all of them. That needs to be reviewed.
And it's not involved in this case, right? This is not a situation because the mortgage escrow account purports to apply to all mortgage lenders.
Correct. Yes. And so then you get into whether it prevents a national bank from being able to do one of the powers that they were granted by federal law. And Alan, you got into an example that's specifically addressed in Cantero and other cases of being able to operate specific types of businesses. So that would be preventing. Where we run into really, I think the nuance is with the significantly interfere. And that's really what we were getting at here. Does that significantly interfere? If you have to provide a disclosure, does that significantly interfere? If you have to provide statements or you have to provide a copy of the loan agreement marked paid in full, there's a number of different topics, and you're looking at not just within that topic, but within the specific state laws within that topic, whether those significantly interfere. So that's where I think that we are with the standard, with the preemption standard currently.
Yeah, and banks, national banks, have often made the argument that if you basically say there's no National Bank Act preemption, we're going to end up having to comply with a patchwork of 50 state laws, all of them of which could be different on a particular subject. We may even have to have 50 sets of contracts, one for each state. Huge burden. That didn't appeal to the First Circuit. And I know that argument was made by Citizens Bank. What did they think of it, Joseph?
It did not go well with the First Circuit. And they said that Congress explicitly rejected that a patchwork would be unworkable when it passed Dodd-Frank. The First Circuit pointed out that national banks have always been subject to at least some state laws, and that a patchwork of differing state requirements is not by itself enough to show significant interference. They essentially said that if Congress wanted to immunize national banks from state regulation, they could have done so, but Congress did not. I'd point out again my jealousy that I had of national banks when I was at a state bank. So this is the patchwork approach is something that state banks have been following for a very long time. And there's a list of different state laws that they look at to make sure that their agreements follow. And I'd say your point is a good one, Alan, on having 50 different contracts. I think that entities who are subject to or have been historically subject to state laws have found ways to design products so that their contract can address state nuances, and we regularly help people put those in. But I think it's more just kind of identifying now, hey, those are things that you're going to have to be aware of and figure out if it does significantly interfere, and if not, how to comply with those.
So, Ron, based on what we've described so far, does this decision mean that national banks are going to have to or may have to comply with all state laws that by their terms purport to apply to national banks as well as other entities in the state? And if so, why is that the case?
Well, I think we have to do exactly what the Supreme Court said to do in Cantero and what the Conti case says, and that is to look at these on a case-by-case basis and look at the state law, determine whether or not it's preempted by, applying the analysis that's articulated in Cantero and Conti, and determine. I think in most cases, it probably does mean that the national bank is going to have to comply with state laws, but there certainly can be cases where that won't apply.
Yeah. So basically, what we're talking about is a very time-consuming and potentially a costly process for every national bank. Not just national banks engaged in interstate transactions, but also even within a state, I guess. You could have this an issue. And when there are multiple states involved, it becomes even more complicated because you got to figure out which state law do you have to comply with. Maybe you have to comply with both state laws and you have to reconcile the state laws. That's something I guess you, Joseph, have a lot of experience with, right? I mean, you mentioned that, and I know you worked for a large state chartered bank, and my guess is you had to go through that process, right? You had to, and I assume this bank was doing business in all 50 states.
Absolutely. And there are a number of state banks that do business in all 50 states today. So there are the challenges difficult? Yes, but they're not insurmountable. So, I think it's number one, having that inventory of state laws that are possibly applicable. And I think that once you have that inventory, you're going to look at a lot of them and realize, hey, we're already complying with a number of these. There might be some of those that are on the edge that you're like, hey, we can make a couple of tweaks to comply with these different state laws. But, having that inventory of what they are is most important. And like I've done that in-house. We now advise a number of other banks on these and some national banks who have been getting ready for this too.
Oh, yeah. Yeah. I mean, we started ramping up for this process for a lot of our National Bank Act clients as soon as Cantero came down. Because, that to me, signaled there was trouble ahead. And now, we've seen one shoe drop. But am I right? This isn't the only case, right? There are a couple of other cases. What can you tell us about that?
Yeah, I mean, we saw Cantero. We've got this. There's a couple of other cases that are out there in the Second and Ninth Circuit. We're also seeing some smaller state cases. We blogged about a Wisconsin district court case that was looking at Wisconsin specific requirements under the Cantero standard. So it is something that's being evaluated. I think that this again goes to why it's so important to have that inventory of state laws and know which ones banks are complying with and which ones there might be risk under, because we've talked a little bit about the compliance burden, but in addition to that, there's a litigation risk here as well. Like that's what we saw in the Wisconsin case of finding out that, hey, there's a state law that applies to us. Better to be aware of those before they're discussed at a state district court case than discover the patchwork, again, to use that language, of state laws through litigation and maybe in some cases class action litigation.
Right. Well, and indeed, the Conti case is a putative class action. There are two cases in the Court of Appeals that are left. Ron, do you want to just mention those cases and put them on the radar of people, or Joseph?
Yeah, the Cantero case back down a remand, the Kivett case in California as well at the circuit court level. I think very similar issue. We're going to get more about preemption, and this goes to what could happen with this case as well. And that, I think I'll turn it over to Ron on. He's been thinking about some of this as well.
Sure. I mean, they could petition for a rehearing en banc and have the whole circuit court hear the case. They could, of course, it's going back down to the district court, so they might have arguments that they're going to make. It's kind of hard to imagine what those are going to be with respect to the reason that we were here in the first place.
Well, yeah, let's take, I think there's sort of three options, and you've identified two. A petition for rehearing, Ron, is really hard to get granted, right? Particularly where there's no dissent. There's a unanimous opinion of the panel in Conti. Odds probably not so good, right?
It seems like it's really not so good. I mean, the only thing that maybe could tip that would be if the OCC came out and really expressed a very strong opinion in an amicus brief or something that would request that. But aside from that, it's hard to imagine a rehearing en banc.
Yeah, and then you mentioned, well, they could decide just go back to the district court and start litigating again. I've heard
that's right. I mean, they could develop a factual record theoretically.
That's what I heard. I've heard one person say about this case, well, this came up on a motion to dismiss. There's been no factual record developed at all. And they denied the motion to dismiss of the bank. So now you go back and it becomes regular litigation. And then it's a class action, so you got to deal with class certification at some point. I can't imagine, and maybe I'm missing something, Ron, but what kind of, given this opinion, do you think there's a way to develop a factual record that's going to change the outcome, either at the district court level or at the Court of Appeals level if it goes back up there again?
Sure. I think it's very difficult for them to establish a factual record that would change the outcome in this case. The basis for the motion to dismiss was that the National Bank Act preempted these laws just in general, that they were essentially that the National Bank Act occupied the field, or that anything that was affecting the bank's ability to engage in lending activity would be preempted. The court rejected that. It rejected it in Cantero, and it rejected it here in this case as well. Alternatively, the patchwork theory that we talked about, that it's difficult for banks to comply with a patchwork of regulations from each of the states in which they're trying to do business. The courts rejected that as well. So it's difficult to imagine what those facts might be that would put this bank in a unique position, or that there would be something here, but it remains to be seen.
Yeah, and I agree with you. And in fact, I wouldn't be surprised if the plaintiff, after Citizens Bank, if they do decide to go back to the district court and they file an answer, the plaintiff might seek judgment on the pleadings based on the Court of Appeals opinion without there being any discovery at all. And in the lower court, although the bank might seek discovery, I'm sure the plaintiff will oppose it, and the judge will decide whether to allow discovery. We know what the interest rate is. Am I right? It's not the interest rate you have to pay on mortgage escrow accounts is not a lot. It's it's way less than 1%.
In Rhode Island, yeah, it's based on what is the rate that the bank pays on its regular savings accounts, or alternatively, if there are no regular savings accounts, if the bank doesn't offer them, then it's a rate determined by the commissioner, which is currently 0.5%.
Yeah. So the third option is a petition for a writ of certiorari. What do you think the odds are of that? They've heard this issue once. Don't you think they're going to want to see if the First Circuit got it right?
Well, I think they always prefer not to hear cases, so you start from that assumption. I think if the Second and the Ninth Circuits go in a different way, or if one of them does, then I think it's likely that the Supreme Court would take it up. If I were betting, I would not bet on either the Second or the Ninth Circuit going in a different direction than what the First Circuit did here.
Do you think there's anything, I'm just thinking of other alternatives. I guess amending the National Bank Act would be nice. There'd probably be strong Republican support for that. The question is, how do you get to 60 votes, right?
That's just it.
Yeah. That probably is a non-starter. What about the OCC? I guess they might decide to change their regs, but I don't know how that's going to help.
It doesn't seem like it would, given the Loper-Bright decision and overturning of the Chevron deference standard, and with really what the Supreme Court has said in Cantero, that how could the OCC come up with a reasonable interpretation that does anything different? So
we're back. I guess we've gone for a full circle, and I'm going to go back to you, Joseph, with really it might be my penultimate question before we conclude this podcast, and that is, what should national banks be doing right now? What do? They hire you or Ron, and you end up doing a survey of some type? Can you tell us a little bit about that?
Yeah, I'd say we use one of the existing surveys that we have, Alan. I'm looking at a list of 36 different state law surveys that we've been working with as we've been advising banks on these topics, and they're broken down by topic. But it's really, the approach is really, number one, identifying the state laws that could potentially apply based on the products and services that are offered by the bank. So that's number one. What are those state laws? Number two, then, I'd say, is conducting a gap analysis. You have the state laws that purport to apply. What are the ones with which you are not complying currently? Once you have those, then you can really look at, are some of those preempted? It's possible that there are good arguments under this standard that some of those are preempted, especially the ones when you look at them and say, you'll be able to put them in a category. This would be very difficult if we had to comply with this law. This was going to be fairly simple to comply with. If it's fairly simple to comply with the state law, it's going to be more difficult to argue that that law significantly interferes with the bank's ability to operate as a bank and have the powers that it's been granted. So then look at what ones you can comply with, which ones you can't, and then you're looking at operationalizing and implementing those different laws. That's like the one-time piece. And then you're looking at what laws are happening, as they continue to be promulgated. We're seeing more things happen at the state level. This and other cases, I'd say, are invigorating state attorneys general and banking regulators that they have state laws already and they can be looking at state laws. But first and foremost, I'd say, is just getting that baseline of making sure that you're comfortable with your posture with respect to existing state laws.
Yeah. Do you have anything you want to add to that, Ron, or is Joseph pretty much summarized, what the right approach is here?
Yeah, I think he has. Unfortunately, we've done a lot of that just from representing state banks in this field.
Right. So I'm going to throw a curveball at both of you. I know you're not expecting this question, but this is something that really occurred to me, and it's really bothering me. National banks, I think most of them exercised reasonable business judgment in deciding to rely on OCC regulations that were issued in '04 and have been in effect to this day. They're still on the books. And it just seems incredibly unfair to tag what I'm basically saying, to make this opinion, the Conti opinion, retroactive. I'm wondering if there might be an argument that could be made, constitutional or otherwise, to the effect that this opinion should only apply prospectively, let's say Cantero, after the mandate gets issued and there's no longer a petition for rehearing en banc or no prospect of a cert petition, to give national banks an opportunity to come into conformity with state law. It seems really, as I said, very unfair to apply something that really is a big change from what the OCC has been telling them is okay. Any reaction to that, or is this very much pie in the sky?
It's a great question. I personally think we're going to see more of this in a post-Loper Bright world, as Ron was mentioning earlier. The ability or the requirement that courts really give more deference to regulators, that's gone. So I think that not just in banking, I think we're going to see that reliance on regulators may not have the same kind of standing that it's always had. And I would say we've been a little skeptical of some of the regulations from the OCC in this area for quite some time. So I think that, while, yeah, it is unfair, I don't think that it's entirely beyond the realm of what was possibly expected.
Yeah. Just one thing I want to add to that. In the Loper Bright opinion, which is the Supreme Court case that basically overruled the Chevron opinion that says that you've got to defer to a federal agency's regulation if the statute is vague on the subject or unclear, and the regulation is a reasonable interpretation of the statute. In that opinion, they did go out of their way in Loper Bright to say, however, if there's already binding precedent that's been issued by a court, and I'm thinking of the Smiley versus Citibank opinion of the Supreme Court, the case that held that a late fee constitutes interest under Section 85 of the National Bank Act. I recognize, this case doesn't deal with Section 85, but basically I had this fear that Loper Bright might result. And in that case, by the way, the Supreme Court's opinion was based entirely on giving Chevron deference. There was a regulation promulgated by the OCC on the eve of the case being considered by the Supreme Court. So here, we don't have any kind of precedent like a Supreme Court precedent that our clients have been relying upon, but we've got an OCC regulation that's very old, been on the books 21 years. Most of the industry, I think, has been relying upon it as being a fair reflection of what the law is. It's never, until these cases came up, nobody ever thought, maybe we did as lawyers, but I don't think too many national banks lost a lot of sleep over their decision to follow what the comptroller is telling them is okay. So my hope,
I'll add one thing to that, Alan. Yes, we may have, as lawyers, there were also letters sent, though, by senators, people in Congress, expressing that they thought that the OCC was wrong and what the OCC was doing was not in line with what they were expecting when they passed Dodd-Frank. So, yes, I agree, but there were others out there too.
Yeah, I know. Okay. I don't know if either of you have anything more that you'd like to add to what we've already covered. I think we've pretty much covered this case pretty thoroughly. I'm sure as there are further developments, either in this case or if an opinion comes down in Cantero or the Livet case in the Ninth Circuit, we'll be doing future podcasts. But I want to give each of you an opportunity to add anything else that we may have overlooked.
I guess the one thing that's interesting to me that I would think about is what is really the value of a national bank charter if in the context of consumer banking? Because if these cases go the way we anticipate that they will, there's really no difference in the context of consumer banking between the national charter and a federal and a state charter.
Yeah. Well, that's a good point, Ron. You're right, because we talked about Section 85 of the National Bank Act, and there is an analog to that section, I think it's 21 of the Federal Deposit.
Section 27.
27, yeah. I'm sorry. Federal Deposit Insurance Act, which is based on Section 85 and was intended to confer on state-chartered FDIC-insured banks the same interest rate authority national banks have under Section 85. There's an opt-out issue that we don't have time to get into for state-chartered banks. But you're right. It really depreciates the value of a national bank charter. Okay. I want to thank both of you for taking the time on very short notice. This opinion just came down to absorb everything in the opinion and your willingness to share your thoughts with our audience. So to make sure you don't miss any of our future episodes, please subscribe to our show on your favorite podcast platform, be it Apple Podcasts, YouTube, Spotify, or wherever you listen. And don't forget to check out our blog, consumerfinancemonitor.com, for daily insights on the consumer finance industry. And if you have any questions or suggestions for our show, please let us know about it. You can email us at podcastsingular@ballardspar.com, or you can just contact me at Ballard Spar. I often get suggestions for our show, and I very frequently act on them. So stay tuned each Thursday for a new episode of our show. And thank you for listening, and have a good day.